What's the meaning of the word will? When you really think about it, your will means your wishes. It's my will that this is what will happen with my property after I pass away. And so we tend to think that when we make our wills, that's what's going to happen. What's set out in that document, our will, is what's going to happen with our estates. But that is not necessarily the case. The law does make provision for people who are not left a fair share of an estate in some circumstances to challenge a will on the basis that it does not provide adequately for their maintenance and support. I acted for 4 children, each in their early 20s, who were left only $500 each in their father's will. This was out of an estate that was worth well over $1 million. One of these young adults, my clients, who I'll call Bernard, is legally blind as well as hearing impaired, and he has a multitude of other health problems. He has no chance of ever earning an income, and he will always require a carer. I can't comprehend how Bernard's father thought it was adequate to leave Bernard just $500 out of his estate worth well over $1 million. So we applied to the court for further provision from the estate for Bernard, his sister, and 2 of his brothers. Our claim was hotly contested by 2 other adult sons of the deceased, as well as the deceased's last wife. We eventually managed to settle out of court after a mediation that lasted from morning until evening, with 21 people involved, including lawyers. We finally managed to get an out-of-court settlement that made fairer provision for Bernard and his brothers and sister. So it's a good law, it's a good rule of law that enables needy children and spouses and other dependents to claim further provision from an estate. Another example is a client who I'll call Adrian. Adrian's father passed away and left his whole estate to his wife, not Adrian's mother. Adrian's mother had passed away some years previously, and in fact Adrian's mother and father had been separated and divorced some years before that. So Adrian's father died, leaving his entire estate to his second wife, who I'll call Raylene. Now, at the time of Adrian's father's passing, Raylene had a will that, if she had died at that time, would have left half of her estate to Adrian, with the other half of her estate going to her niece and nephew. So, in essence, if she had passed away with that as her will, then Adrian would have received his father's estate, essentially, and Raylene would have been able to deal with her half of the estate however she saw fit. But, as these things happen, Raylene changed her will to leave her estate to her niece and nephew, cutting Adrian out of the will completely. We contested the will on Adrian's behalf. The argument that we put to the Supreme Court of Queensland was that Raylene's estate consisted largely of a benefit that she had received from Adrian's father, and so the court should be more ready to conclude that Raylene should have made provision for Adrian in her will. The Supreme Court agreed with us and made an order giving Adrian $900,000 out of an estate that Raylene left of about $2.4 million. And the court has observed that where stepchildren, and Adrian was Raylene's stepson, where stepchildren step aside and don't contest their natural parents' will, as happened here, where Adrian simply did nothing to contest his father's will that left his entire estate to Raylene. Where a stepchild doesn't contest that, then they do have a right to come forward later when their step-parent passes away and say, it's time for me to receive fair provision, adequate provision from my step-parent's estate.